As the last presentation of the day, I will outline how the UPC grants remedies. So in line with also what Gwendal has just elaborated on, and how it applies proportionality principles in practice. And I will also look at a few recent judgments that illustrate the developments from the last 2 years, and I will end with some practical notes. Perhaps because of the time, skip to the practical takeaways. Well, under the UPC agreement, just as Gwendal just said, parties may seek interim remedies at various stages, even before main infringement action begins. And well, the first one is just the preserved evidence and the inspection of premises. But there's also the possibility of freezing orders. So that means at the request of the applicant, the court may prohibit the party from removing or dealing with assets within or beyond its jurisdiction that may be infringing. And there's also the possibility of provisional measures. And for instance, these can be, well, injunctions, preliminary injunctions, the seizure of goods that are suspected of infringing a patent, an interim award of costs, and also precautionary seizures of defendants' movable or immovable property, such as bank accounts. And it's good to notice that these measures are temporary, so they can be invoked if the applicant fails to follow up with main proceedings, and it should be within 20 days from the ground of the PI. But next to the interim remedies, there's also possibility of final remedies. And once infringement is proven, the UPC may grant full range of remedies under UPCA, and each measure is tested also for proportionality. The first one is instead of the preliminary injunction, it's the permanent injunction. This prohibits the continuation of infringement for all UPCA member states where the patent is valid. Then there's also the corrective measures. So for instance, recall and destruction of infringing goods, also delivery up of them or removal of the product from the market or deprivation from infringing characteristics. And there's a possibility of disclosure of information, mostly requiring details on origin or distribution or quantities to enable damage calculation. And then to restore the injured party to the position absent of infringement, there's also a possibility of award of damages and also for cost of the legal costs. And last, there's also a possibility of publication of the judgment. And that's mostly used for publication in the public media, so not by the court, but for instance, on the website of the infringing party. And there's also a possibility of declaration of non-infringement or revocation for a possible infringing party. Then I guess I'll skip some of these because of the time, but it's good to notice that also in default judgments, the court can award some remedies, but still there's a proportionality review, even if the defendant does not file a statement of defense or does not respond. And there also the possibility in PI cases to award these remedies. Then one of the most important things for this presentation is that in Article 63 of the UPCA, the court is given the discretion by a word may to issue injunctions. But in practice, injunctions will follow almost automatically once infringement is found. So only in exceptional cases may the injunction be refused of disproportionality. And the infringer has the burden of presentation and proof for the lack of disproportionality based on the Article 54 of the UPCA. And this was also confirmed in the recent Court of Appeal decision of 3 October 2025, Belkin versus Phillips. And also the Mannheim Local Division of 2 April 2025, that's shown on the screen, confirmed that disproportionality arguments have not yet succeeded in any main action. But this is different for preliminary injunction cases. And then some key considerations for remedies under the UPC 8 of the last 2 years. Well, for normal damages awards, they're typically awarded when infringement and validity are established, and the exact amount is often determined in separate proceedings following up on the main proceedings. There are some limitation periods that the court considers, and also provisional protection. But it's good to know that there's no need for prior warning by the patentee. Defendants are expected to monitor the competitor's IP rights. Then there's also a possibility in Article 68 that says there's a possibility for claim of moral prejudice, and that's only awarded in exceptional cases, and the patentee must show special circumstances justifying such compensation, for example, reputational harm. And also interim award of damages is rarely granted. The patentee must demonstrate clear justification and urgency. Then the disclosure of information. It's commonly granted to enable the calculation of damages, and courts may impose protective measures to safeguard confidential or sensitive customer relationships. And for the destruction of infringing goods, it's good to know that they're also frequently granted unless if they're proven disproportionate. And the infringer must demonstrate why the destruction would be excessive. And also environmental concerns alone usually do not suffice. Then regarding the recall of infringing products, these are often granted, especially for commercial distribution, but they may be limited to professional or commercial customers only. And there's also a possibility of removal from channels of commerce, and those are typically ordered to prevent further circulation of infringing goods. And the last is that the publication of decision in public media is granted only in exceptional circumstances. And the applicant must show that the publication is necessary to remedy harm that cannot be addressed otherwise, but otherwise it will be purely punitive, and that's not allowed. I will also skip the enforcement and go to my conclusions that the UPC's early case law reveals mainly consistent and harmonized approach with a wide range of tools for claimants, but proportionality acts as a control mechanism for a ballast system, though rarely decisive so far in not allowing injunction if there's an infringement, at least in main cases. And enforcement is also European in scope and uniform in recognition, and increasingly efficient to help the system. Thank you.